A Nassau County man charged with murdering his wife and two adult children in December of last year may not stand trial. According to a psychologist, William Broyles is not competent for prosecution. Broyles was a music minister for more than 20 years at a local church. The sheriff says he killed his family. After he killed his family, he called deputies and reported the crime, then surrendered to them standing in his driveway. News4 Jax reporter Joe McLean has been talking with legal experts. He's joining us with more on Broyles' court appearance today. Joe?
During a hearing today, Tom, Broyles' attorney said that a doctor had examined Broyles and found that, as you said, he was not competent to stand trial. Now, what that tees up is what's called a competency hearing, which those legal experts tell me is a big uphill battle for the defense. William Conway Broyles had been a longtime church music director, a father to 3 grown children, and a husband of 30 years. But on December 1st of last year, he became the subject of a murder investigation. Police say he shot his wife and 2 of his children to death. Broyles was arrested that day and soon after placed on suicide watch while in custody. But before the criminal trial gets underway, the court has to make sure he's legally able to be a defendant. Broyles' attorney told the judge on Thursday that a doctor found that his client was incompetent to stand trial. I spoke to Benjamin Priester, a law professor and an attorney not affiliated with this case. What does it mean to be legally incompetent?
The legal standard for competency to stand trial asks whether the defendant can understand the proceedings against them and whether they can assist their attorney in preparing their defense.
Notably, Priester said, in a pretrial hearing like this, the burden of proof is actually on the defendant, not the state. And Priester said it's a heavy burden. Nothing's off limits about the defendant's history.
The prosecution's argument is going to be, this person doesn't appear to have any long-standing, well-known history of mental disturbance, which is going to lead the prosecution to say, we're skeptical of this claim of insanity, or we're skeptical of this claim of incompetency to stand trial, because it is, relatively speaking, unusual for people to have a sudden break with reality.
Broyles' lawyer said he still wants his client to meet with a psychiatrist, an investigator, a therapist, and his minister before the next hearing. And that next hearing is happening on April 7th, and that's really going to let us know where this case is going to go. If Broyles is eventually found to be competent to stand trial, his lawyer indicated during the hearing today that he plans to waive Broyles' right to a speedy trial, and that means this case could go on for months or even years. Reporting live in Nassau County, Joe McLean, Channel 4, the local station.
Joe, what about the other possibility? What if Broyles is ruled incompetent to stand trial? Then what?
Well, in that scenario, Broyles, he certainly wouldn't just be let go and the case dropped and everything's fine and he's back in the general public. Broyles, according to Priester, said he'd likely be involuntarily committed to a psychiatric facility to get mental health treatment for a mental health illness. However, if he recovers from the illness, Priester said Broyles could potentially be tried after his recovery for these crimes. Back to you.
Joe McLean reporting to us live from Nassau County. Thank you, Joe.